Welcome. So this week, I just want to quickly talk about a couple of things to do with the final exam and the upcoming policy memo. So we've just done 4 weeks of copyright, 3 weeks of substantive content of copyright, and a week of review coming up. What is really clear to me in talking to some of you over the last couple of weeks, and in my experience in previous years, is that you really need to practice doing practical copyright questions. So we need to make sure for the final exam that you're able to go through and very easily apply the basics of the law to the issues and the facts that you'll be given. We're not trying to trick you in the final exam. The final exam measures your ability to apply the law. This is not going to be a research problem. It's not going to be so much a problem of policy and critical analysis as you'll face in the policy memo. Rather, we just want to make sure that you can very clearly and very correctly apply the law to a fact situation. So these are the basic sort of questions that you'll get if you're in the first years of legal practice and someone comes to you with an IP problem. They're not going to be super advanced IP problems. We're not going to try to trip you up with really tricky and unclear issues of the law. But what we do expect of you is that you can apply the law correctly. And it's going to be hard for you if you don't have the time to practice that application, because you'll be relying on really half marks here and there to try to scrape through. And from my experience in the past, that is very difficult to do because what I am looking for when I'm marking an exam is not a statement of law. I don't want to know what the textbook says about substantial part. What I want, and the only thing that gets you marks in the exam, is the application of the law to the particular facts at hand. And that's something that is really, really difficult to cram at. The only way, in my experience, to get good at that is practice. So to help you do that, I want to do a few different things. The first thing, this week in the internal workshops and online on Piazza, I'm going to be posting, or I have posted, a series of practical questions. Now, I want you to work in groups to answer those questions and upload your answers to the Piazza interface. That way, other people can come in, contribute, refine the answers, and hopefully by the end of that process, in a few weeks' time, we will have a good answer to the questions that I've posted up there. And if we need more questions, I'll post more questions. But let's start with the 5 or 6 that I've got up there now. So if you create collaborative answers to the questions that I post, I will then go through at a certain date, we'll draw a line, and at that point, I will go through and mark your answers. Now in this process, I'm going to live stream what I do when I go through and mark an exam answer. And I'll do this each time for copyright, for trademark, for patents, and give you an idea of where you pick up marks, where you lose marks, and how you can improve. Now, I can't do this for 150 different people individually, but I can do it if you create the collaborative answers that I'm envisaging. Okay, so I'm happy to talk about dates, and I might put up a poll just to make sure that you have enough time to do this. I think it works better if we have it closer to the subject matter. So having, for example, the copyright answers due and reviewed over the next 2 weeks, but I am sensitive to the fact that you've got assignments due soon too. So if that doesn't work for you, let me know. I'll put up a poll on Piazza. Okay, next, I want to talk about the policy memo. So the policy memo is writing a submission for a particular purpose to the Attorney General's Department. And your purpose is to convince the department that your particular option for law reform is the best option for law reform. Now to do that, you're going to have to make an argument that is clear and persuasive. It is really, really important to remember who you're writing to. So always picture the audience and make sure that the message that you're writing, the argument that you're making, is targeted at that particular audience. So this is why, first, the executive summary is so important, because these things come across the desks of very busy people who need to know immediately what it is that you're saying, what your preferred option for reform is, and why the main points are, or what main points in support of that you're relying on. You need to have that crystal clear right at the start. And the executive summary is not an introduction. I don't want you to write, in this submission, I will go through the main arguments and conclude something. What you need to do is say, in this submission, I argue that Australia should not accept any changes to the GI regime because this would unfairly prejudice the Australian domestic growers on these 4 grounds. Something like that. Really simple. It's basically the conclusion of your work put up front in a very simplified form. Then the argument itself, the body of the work. So in this exercise, you're an academic, or you're writing an academic style submission. So the way you're going to make your submission persuasive is to back up your arguments with reference to what we know in the secondary literature. So I expect here that this is a research exercise. You're not going to be able to answer these questions by relying on the law. So let me take an example. If you're doing the patent question, you're not going to be able to say that one of these options, that the gene patent should be allowed because it makes sense within the framework of our existing legislation. That's not the question you're being asked. The minister and the department here want to know why we should create legislation that achieves this particular result. So it's an argument about the objectives of the IP scheme and the best way to fulfill those objectives. You can't answer that from within the existing case law so you can't answer that from within the existing legislative framework. It's a question about reforming the legislation. And you need then to have reference to some external values. You say that one of these particular options is more efficient, and you can back that up. Or it's more effective at stimulating innovation, which is a good thing that we should encourage, and you back those points up. Or you say that this particular outcome would be unfair, and it would unfairly prejudice these 3 groups, for example, and you back that up. So you need to be able to back up your submission with reference to the academic literature. And that's what I'm going to be looking for. The other things that I'm looking for are critical analysis. So this submission really tests your ability to think about the reasons that we have IP and how we should curtail the boundaries of IP in order to best achieve social outcomes. There are no right answers in any of these questions. These are legitimately hard questions that are open for debate. You need to make some sort of argument, but in doing that, you need to be persuasive and you need to adopt an academic tone. Now, when I say the word argument, what I want you to be careful of is that I don't want what we call a polemic. I don't want you just to really forcefully present one side of the issue. That's not going to be persuasive to your audience. Your audience needs to see you develop a reasoned, clear, and careful argument and analysis and come to some sort of reasoned conclusion in support of your particular outcome. I don't mind what outcome you choose, as long as you justify it with reference to the evidence, to the secondary resources that you're relying upon, and that you're careful, that you don't overstate your case. It's really easy to lose your reader if you look like you're just reading the literature to only look to support your points. You need to be careful and you need to engage with the limitations of your argument in order that you can show that even though other people might disagree, your particular option should be preferred for these reasons. The other thing that you should be really careful about in terms of thinking about your audience is you just got to get to the point. You have to make your argument clearly and you need to back it up. You don't have time to explain the law or explain the background and so on and so on. Remember, you're writing to an expert audience. You're writing to the Attorney General's Department. So you can assume that the Attorney General's Department knows about what patent law protects and doesn't, what GI protects and doesn't. You don't need to explain to them a textbook answer that explains what the GI regime actually is. You're going to need to do that research so that you know what the GI regime is, but don't put it in the submission. In the submission, you can assume a certain level of knowledge. So the issue in, let's continue with GIs, is should we extend or should we limit it? Now, there's no point devoting a whole page or even a whole paragraph really to setting out what our current law is. You need to really quickly get to the point of your analysis and argument and focus all of your time on making a convincing and persuasive argument for a particular outcome. So looking at each one of the three questions briefly. The first one, as I've hinted, is about geographical indications. So the GI regime essentially protects the use of certain words that are related to the geographical origin of a particular product. So champagne can only legitimately be made in a particular area of France according to a particular process. That's why in Australia we don't have champagne, we have sparkling wine or wine made according to a traditional method champenoise. Those growers, though the people who have long established reputations as being the best for particular types of products, they want to maintain a monopoly over that reputation. So they develop a GI regime that enables them to say, we can call anyone here following this process can call our wine champagne. Anyone else may not use that word as a description of what they're doing. And that has a certain cultural significance, right? There's a cachet associated with the word champagne that doesn't follow the word sparkling wine, even though it doesn't necessarily tell us anything about quality of the particular wine being consumed. It helps consumers understand that their wine comes from a particular place with particular standards or particular history. So you can see why the French and other European nations are very keen to protect their historical dominance in these areas. Now, Australian growers, of course, are less keen because you can sell wine that is labelled champagne at a more expensive, more profitable rate than you can sell wine that's labelled sparkling wine. So for Australian growers who haven't had the long history of producing this to create a particular reputation in their growth, they want to be able to use those words as a descriptive name. So they want to be able to say, for example, that the sparkling wine produced in this particular region is also champagne because it's made in the same way. And they say that champagne has become really no longer an indication that a product was made in the Champagne region, but instead it's a descriptive, it's a description of the style of a particular product. Same with feta and other things, parmesan, so on and so on. So that's the basic and historical outlines of the debate. It may be now that some Australian producers want more protection for things where we are in industries where we are world leading, and we might want to start protecting our reputation in the world stage in the particular areas that we have developed expertise in. So maybe that might be a good reason to change. You're going to have to work through those debates in order to understand how Australian law should adapt, if at all. Okay, second, trademark dilution. This is a really interesting area. Trademark dilution is something that has become more important with globalization and the increase of global brands. So trademark historically has always been about consumers, or at least we think it has, we say it has. We've always said that trademark exists to prevent consumer confusion. It exists to reduce the search costs of consumers in finding the products and enabling consumers to know that their products come from a particular source and that they can rely on that without having to go beyond the label to look for other indications of quality or quality control. Trademark dilution is the name given for the protection of trademark that is not about confusion. So when consumers are not likely to be confused about the use of the words, but brand owners don't like it because it puts their brand in a particular bad light. So no one would believe that Louis Vuitton actually manufactures the Chewy Vuitton brand of dog toys, right? So it can't succeed under a normal trademark infringement action. Louis Vuitton's claim here is not that people will be confused, it's that they've spent so much money creating this globally recognized brand that other people shouldn't either be able to free ride off that investment. And you can make that argument in a number of different ways, as you'll see in the literature. But in the end, it comes down to whether we want, either as a matter of fairness or in order to incentivize brand owners, whether we want to protect a broader monopoly of global brands. Now, there are changes in the market as brands become more diversified that might make us think that it is important to protect these sorts of investments. Or we might think that it's important to encourage branding because branding itself is a good thing for whatever reason. You need to be able to back up that argument if you're going to make it. Alternatively, you might want to take the argument of competitors, that competition is a good thing and these types of uses are types of uses that we should encourage because they encourage competition. This argument says that it would be a bad outcome for consumers if we were to unduly strengthen the monopoly of brand owners because it would prevent people from being able to use certain words in their advertisements. Alternatively, you might be concerned about consumer interests. Take, for example, that Australian case that you'll come across. There was a guy who was dressed up as Super Mario, and he was an amateur wrestler. Now, that was a trademark infringement brought by Nintendo. Nintendo didn't argue that people would be confused that this person was actually endorsed by Nintendo. What they say is that they've spent a long time building their reputation in this and that they need to be able to control the way in which their images are used. Now, that's a really strange argument from the perspective of trademark law, which has always been about confusion. But it is a strong argument from Nintendo. On the other hand, you might be concerned about expression. You might say that people have a right to play with these sorts of cultural products and that brands are such a part of our lives that we need to be able to use those brands and express ourselves through those brands. So think of the Barbie girl example as part of this assignment question. So that's the basic outlines of this problem. You need to be able to make an argument based on one of those, or maybe a different, policy position that we should prefer either strengthening or not strengthening the restrictions on non-confusing uses of trademarks in order to achieve a certain outcome. Now again, you can't do this from within the confines of the law. The Attorney General is not interested in what the law is. The department wants to know why they should extend or limit or do nothing this particular action. Finally, we get to gene patents, and we've spoken a little bit about these in previous weeks. So you know what the core issue is. It's a debate about whether someone who is isolating an already existing gene should be entitled to patent protection over that isolated gene. So the way this plays out typically is that patent owners say, medical researchers who own patents say that they need protection over this type of work because it's expensive to carry out. And if they don't get protection, they will lose the incentives to actually engage in research that is useful and beneficial to society. Other groups, consumer groups, might say these types of patents increase the costs of detection and increase the costs of using those particular genes so much that they end up being bad for society because the costs to the public outweigh the benefits to the public of providing the incentive to the researchers. Other people might say it's not fair to give a patent to someone who has merely someone who's merely isolated an existing thing. They might base their argument on the fact that these things are already existing in nature and they can't be owned by corporations. And you can explore that argument a little bit further. It's got roots in the traditional knowledge debates about whether or not you can patent the application of seeds or of particular plants for particular purposes. There's lots and lots of material that you can run off in that direction with, and just be careful not to get sidetracked too much. The third argument would be from other researchers who might say this granting patents over this might provide an incentive to the first person who patents it, but it prevents or it provides a disincentive to future researchers. So because the gene wasn't invented by that company, it was just isolated by that company, they might say this unduly restricts the ability of future researchers to engage in valuable research. That's the three main arguments. There might even be a left field argument that says, actually, patent protection is just the wrong way to go about medical research, and maybe we should fund prizes or big government infrastructure. I could see you mounting an argument along those lines, but you'll have a hard time convincing the Attorney General's department. Could be interesting though, but you'd have to work hard to sustain it. So that's an outline of the major issues. For each of these, remember your key task. You need to provide an argument that's convincing for the Attorney General's department. So this will be read, probably won't be read by the Attorney General himself. It will be read by the staffers in the department who are trying to craft legislation to represent the national interest. So you need to be really clear about what you're saying, but you also need, in the body of your work, to be really careful about making sure that your argument is well supported. As academics, we have a particular role to play in this system that encourages really well thought out, really careful, really critical analysis that is independent to an extent. Now, your particular submission here is not quite independent. You represent a think tank, and they usually have particular ideological positions. But it is an academic style submission. So you need to back it up with reference to the academic literature in order for it to be persuasive. Don't make the mistake of being too strong in your arguments. You will lose your audience if they think you're overstating your case. So you need to be really careful. You need to actually say something. You need to have an argument, but you need to weight it. You need to be balanced and you need to be critical. So critical in that sense means that you have made an evaluation and you're sensitive to the limits of your argument. So if we're talking about innovation, for example, in gene patents, it means that you have considered the alternatives, that you've thought about what happens if we protect this or we don't protect this. Who's going to lose out? Who's going to gain? Is the gain to the system worth the losses to the system of the change? So being critical means really being reflective about the quality of the argument you're making and making sure that you're not overstating it. It also means looking really carefully for gaps in the argument. One of the core mistakes that law students make is miss the second step of an argument. I'm always happy to, I won't talk in too much detail about structures of arguments in this video, but if you're interested, I can talk a little bit more about this at a later date. But essentially, you should look up the theories of persuasive argumentation. And the type of argument we're normally making is a syllogistic argument. So this is really a three-part move. You have a general statement, something about, patent law is designed to provide incentives to discover things. You might then have a more specific statement saying that in this case, a patent over an isolated gene provides incentives to people to discover, to invest in the research to discover. And then you've got the therefore statement. Therefore, patents over isolated genes are good because they provide incentives to invest in valuable research. Okay, so that's a three-step syllogistic argument. Lots of people move directly to the therefore from the general statement. And what they do there is miss the really critical part of application that says this outcome is better because of a certain set of factors. That's really, really obvious when you're reading, and it completely ruins the persuasiveness of your argument. So when you say therefore, I want you to be really, really careful about making sure that your conclusion does actually follow from the premises and the arguments that you've made before. So your goal in this policy memo is to make a cohesive and coherent argument from the top all the way to the end of the memo. It's got to be clear, direct, and it has to flow. So you're building an argument that builds upon itself at each step of the way. Each paragraph is a mini argument. Each paragraph then, within itself, so each sentence in paragraph builds upon, creates a new argument that you will then use to build your larger argument. So that leads to some really important points about paragraph structure. Your first sentence in the paragraph should be the conclusion of the argument that you're making in that paragraph. So that's a topic sentence. The topic sentence should always be the next rhetorical move in the argument of the entire piece. Be careful about that because it's not the way we normally write. We tend to leave the conclusion to the last sentence of the paragraph, and that's dangerous. Essentially, a reader should be able to pick up your submission and get every move in the argument just by reading the first line of every paragraph. And then the body of the paragraph, the next sentences within that, make up the argument that proves that premise. And then the last sentence of the paragraph links on to the next one. Now, if you do that, it will be much more persuasive. The mistake that lots of people make in their writing is to write general paragraphs and then write a therefore that makes a particular conclusion that's really just not well supported by the sentences that have gone before. And that leads to a structure overall of the whole submission that just isn't persuasive because it contains a whole lot of description that doesn't really go anywhere and then just summarizes with a therefore statement at the end, with a big conclusion. Therefore, the court should ban gene patents. Or sorry, the Attorney General should introduce legislation that bans gene patents. That's not persuasive at all. You need to build that argument all the way through, and you need to be sensitive to the weaknesses, and you need to deal with the limitations of that argument. Now, you can have a look at some of the examples we have. Obviously, if you participated in the drafting process of the last submission we made, that gives you a good idea of the type of thing we're doing. I'd say that last submission isn't well enough justified by the academic literature for the purposes of this, of the policy assignment you're doing today. The policy assignment you're doing today goes to a ministerial department. We're still open to possibilities. The one we did this week is really about specific comments on a particular code to an industry body. Now, they're not going to be interested in all of the academic literature about whether or not they should introduce a code. They're already committed to introducing a code. We just had to comment on that code. Your assignment is not at that stage yet. So the other example we had from last year was the one we wrote to the ministerial departments about whether or not a code should be introduced. And if you go back to that document, the 2014 submission, you'll see that we made an argument that was really well supported by the academic literature. And that's the sort of level of persuasiveness that I want you to aim for to be able to convince the department that your option is the best. Don't be too verbose. Don't explain to the Attorney General what the law is. The Attorney General knows what the law is. Just get to the point. Okay, if you have any questions, please post them as a question on Piazza under the policy submission topic. And otherwise, I look forward to reading your assignments and talking with you about them. And I also look forward to working with you to answer those questions and marking your practical attempts to answer copyright questions this week and other questions in the future. Thanks a lot. Please leave any questions on Piazza.